7:21. John Richard Merrick is scheduled to die tomorrow night. He's been on death row for 25 years for the rape and murder of Adela Marie Simmons, whose body was found in a Dania Beach lifeguard shack back in 1983. Now, Merrick and his attorney have several appeals in the works before the scheduled execution. A Broward judge yesterday struck down one of them. Now, Merrick, he's not just trying to get his execution delayed. He actually wants it overturned because he says he wasn't the one who killed Simmons. He says his friend Raymond Wigley confessed to the crime. Now, Wigley was murdered in prison in 2000. Several witnesses have since come forward saying they heard Wigley's confession. A lot to consider here. Here to explain more about these death row appeals, criminal defense attorney Phillip Menditto. Good to see you again, Phillip.
Good morning. Good to see you.
How are you?
Good.
All right, so there's a lot to consider here. First things first, how do these several witness accounts following Wigley's death play into these appeals? I mean, Merrick's scheduled to die tomorrow.
He is. When you're looking at the death penalty, it's the most severe penalty that the state has.
Right.
So if it's going to be administered, we need to make sure that all evidence has been fully exasperated, fully dissected, and what we're looking for is newly discovered evidence. These three confessions by the co-defendants' cellmates, the judge is looking as though whether these will affect the death sentence that was originally handed down.
Okay, let's talk about the witness accounts. When witnesses are inmates, and I don't know if it was general prison conversation, but does that speak to the credibility here?
It could, but it's a valuable lesson that you tell your client. Whatever happens, whether you're in jail, whether you're out of jail, don't talk to anybody except your lawyer about the case. That's why it's so vital. But it's statements by defendant, and so theoretically it should come in.
Phillip, I'm curious to know, when new information comes in like this, like witnesses' accounts, do they go back to the drawing board and consider old information as well, or is it just strictly on the new information that comes into play?
Well, they're looking at the new information and how it would play out with the old information. Would it have changed the outcome of death penalty? And if it would, then that's obviously going to stay the execution.
Okay, we're going to switch gears now to another very high-profile case that we want to talk to you about. The latest in the Deputy Bleiweiss case. Now, Bleiweiss, just a refresher for you, is accused of forcing at least 8 men, all undocumented immigrants, into performing sex acts with him or risk deportation. Now, his bond hearing was supposed to be Friday. It was delayed. Want to talk about, if he was your client, what would you advise him at this point, and can you shed any light as to why a bond hearing would be delayed at this stage in the game?
First thing I tell my client is this is an enormous case for the state. They have a vested interest in getting either a plea or a guilty verdict. So therefore, you're not dealing with one prosecutor, you're dealing with multiple prosecutors, multiple cops. So when you're on the phone, they're probably recording your conversation. So don't talk to anybody except me in a closed room about the case. Secondly, a bond motion delayed isn't that big of a deal at all. Generally, by and large, you have one chance at a bond motion. So unless you have new information, you're getting one shot at it. So you want to throw every single thing that you have at the judge to give him a reason to give your client a bond.
Okay, Phillip, Bleiweiss' attorney says that, you know, these allegations, they're just blown up. He was just doing his job, and these are taken way out of context. Yeah. But I want to talk about when the accusers are undocumented immigrants and or homeless. Want to talk about credibility once again. How does that factor in here?
Well, as a criminal defense attorney, you're going to either hire a prosecutor, an investigator, do a background search. Look for anything you can, such as inconsistent statements. Did they have a reason to lie? Did they make these statements after they're arrested? You're going to look for every single thing you can to discredit their testimony, see if they have a reason to lie. And you're going to use that not only at trial, but at depositions, every stage of the proceeding.
Right. Okay, Phillip, we do appreciate you weighing in on both of these really hot topics this morning, so thank you once again for being here.
Thanks for having me, Kristen.
All right, well, count on us to follow the developments for you in Merrick's appeal process. Also, if you want to learn more about these cases, they're pretty complicated. We break it all down for you. We have links for you on southflorida.com.